The chainsaw stopped first. Then the hammering started. I was 1,100 miles away, sitting in a rental car outside a hospital in Ohio, when my neighbor sent me a photo that made my stomach drop. It was my fence. My 6-foot cedar privacy fence, the one I'd installed 2 years earlier, the one that ran along the back of my property where my kids used to play and my dog used to sunbathe. In the photo, it was lying in pieces on the grass. Not damaged. Not leaning. Gone. Disassembled, board by board, and stacked in a pile like firewood waiting for someone to haul it away. Standing next to that pile, clipboard in hand, wearing sunglasses she didn't need on an overcast Tuesday, was Denise Calloway, president of the Brookhaven Estates Homeowners Association. A woman who had, according to my neighbor, supervised the entire teardown personally, directing 2 men with a truck like she was conducting an orchestra of destruction. Sit with that for a second. Not, we sent you a notice. Not, we're considering action. She had my fence torn down while I was 1,000 miles away, dealing with a family emergency, with no way to stop it, no chance to argue, no opportunity to even ask why. And here's the part one promise we'll get to. Denise didn't just make a mistake. She made a very specific, very confident, very public mistake. The kind of mistake that gets written into HOA case studies as a cautionary tale. Because 3 days after that fence came down, a single piece of metal buried 18 inches into the ground at the corner of my property would end up costing her the title she'd held for 6 years, and very nearly her own house. I'm Marcus Reyes. I'm a federal law enforcement officer, and at the time, I'd been a homeowner in Brookhaven Estates for just under 3 years. I want to tell you this story the way it actually happened, because if I told you the ending first, you wouldn't believe how something this small turned into something this big. You wouldn't believe that a woman with a laminated rulebook and an attitude problem could lose so much over a fence she never had the right to touch in the first place. This isn't a story about revenge. This is a story about what happens when someone with a little bit of authority convinces themselves they have a lot more authority than they actually do. It's a story about paperwork, property lines, and the quiet, unglamorous power of simply being right and being able to prove it. But before we get to the survey marker, before we get to the board meeting that ended with Denise Calloway's hands visibly shaking, before we get to the moment a police officer asked her a question she clearly wasn't prepared to answer, we have to go back to the beginning. Back to a quiet cul-de-sac, a fence I built with my own 2 hands, and a woman who decided my backyard was her business. So let's start there. To understand how a fence dispute turned into something that ended up in front of the Brookhaven Estates Board, the county, and eventually a sheriff's deputy standing in my driveway, you need to understand 3 things: who I am, what I actually owned, and who Denise Calloway believed herself to be. I bought my house in Brookhaven Estates a little over 3 years before any of this happened. It's a modest neighborhood about 20 minutes outside a mid-sized city, the kind of place with curving streets, mailbox posts that all match because the HOA requires it, and lawns that are mowed on a schedule whether they need it or not. I'm not exaggerating when I say the grass height is technically regulated. Most of the people who live there don't mind. It's quiet, it's safe, the schools are decent, and frankly, after 15 years in federal law enforcement, quiet is something I've come to appreciate more than almost anything else. I work investigations. I won't get into the specifics of my agency or my caseload, because that's not really the point of this story, and it's not something I talk about casually, even now. What matters is that my job has trained me, for better or worse, to do a few specific things almost automatically. I read documents carefully. I don't take verbal claims at face value when there's a paper trail available. And I don't get rattled easily, because in my line of work, getting rattled is how people get hurt or how cases fall apart. That mindset is going to matter a lot later in this story. Hold on to it. My property sits on a corner lot at the end of a cul-de-sac, backing up to a small wooded buffer that separates Brookhaven Estates from the next subdivision over. When I bought the house, the backyard had a sagging, half-rotted wooden fence that the previous owners had clearly neglected for years. One of the first things I did, about 6 months after closing, was replace it. I hired a licensed contractor, pulled the proper permit from the county, and had a 6-foot cedar privacy fence installed along what I understood, at the time, to be my property line. I want to be clear about something, because it's going to come up again. I didn't guess where the property line was. I didn't eyeball it. I pulled my property survey, which I'd received as part of my closing documents when I bought the house, and I used that survey to determine where the fence should go. My contractor cross-referenced it as well, because professional fence companies generally don't want to build something that ends up 6 inches onto a neighbor's land, since that becomes their liability too. The fence went in exactly where the survey said my property ended. I have the permit. I have the contractor's invoice. I have the survey itself, which, as you'll see, becomes the single most important document in this entire story. For roughly 2.5 years, that fence just existed. Nobody complained. Nobody questioned it. My kids played soccer in the yard behind it. My dog, a retriever mix named Tucker, used to flop down in a patch of sun next to it most afternoons. It was, by every measure, an unremarkable fence doing exactly what fences are supposed to do. Then, about 8 months before the day my fence ended up in pieces on my lawn, Denise Calloway became president of the Brookhaven Estates Homeowners Association. I want to be fair to Denise here, because this isn't a story where I'm trying to paint someone as a cartoon villain. Denise wasn't some random troublemaker. She'd lived in the neighborhood for over a decade. She'd served on the board in smaller roles before becoming president, and by most accounts, she genuinely believed she was protecting property values and keeping the neighborhood looking sharp. The problem wasn't her intentions. The problem was how she interpreted the authority that came with her position and how little patience she had for being told she might be wrong about something. From the moment Denise took over as president, the tone of the HOA shifted. Previous boards had sent the occasional polite notice about an overgrown lawn or a trash can left out too long. Denise's board sent something closer to citations. She started walking the neighborhood personally, sometimes with a tape measure, checking fence heights, paint colors, and what she called boundary encroachments, a phrase she used constantly and, as it turned out, didn't fully understand herself. My first real interaction with Denise happened about 2 months before the fence incident, when she stopped me in my driveway to mention, almost in passing, that my fence might be an issue. I asked her what she meant. She said something vague about it possibly being closer to the property line than the HOA's guidelines allowed, and that she'd be looking into it. I told her I had a survey confirming the fence was correctly placed and offered, right then, to show it to her. She waved it off and said she'd follow up later. She never asked to see the survey. Not then, and not for weeks afterward. That detail matters, because it tells you something important about how this entire situation unfolded. This was never really about whether the fence was in the right place. It was about Denise deciding she was right, and then acting on that belief without ever actually checking whether she was. That conversation in the driveway should have been the end of it, or at least the beginning of a normal, boring process where someone asks for documentation and the documentation settles the question. Instead, it was the opening move in something that would escalate far beyond what either of us could have predicted that afternoon. The first real confrontation happened on a Saturday morning, about 6 weeks after that brief exchange in my driveway. I remember the day clearly because I was out front washing my truck, nothing dramatic, just a normal weekend chore, when I saw Denise's white sedan pull up along the curb in front of my house. She got out with her clipboard, and I remember thinking, almost amused at the time, that the clipboard had become something like a prop for her. A way of signaling that whatever conversation was about to happen, it wasn't really a conversation. It was an inspection. "Marcus," she said, walking up the driveway without waiting for an invitation, "we need to talk about your fence." I turned off the hose and gave her my full attention, because in my experience, when someone leads with a tone like that, the worst thing you can do is get defensive before you even know what they're accusing you of. So I just said, "Sure, what's going on?" She held up the clipboard like it was evidence in a trial. "I've had multiple complaints from neighbors that your fence is encroaching past your property line into the buffer zone. That's a direct violation of Section 4, subsection C of the Community Guidelines, which requires all structures to maintain a minimum 3-foot setback from any HOA-designated green space." I want to pause here and point out something that I noticed immediately, even before I responded to her. She said multiple complaints from neighbors, but she never named a single neighbor, then or ever, throughout this entire ordeal. In 3 years of living there, not one neighbor ever personally mentioned an issue with my fence to me. I'm not saying nobody complained. I'm saying that in hindsight, multiple complaints started to feel a lot like a phrase people use when they want their personal opinion to sound like a groundswell of community concern. I told her, calmly, that my fence had been installed using a professional survey and a county permit, and that as far as I knew, it was placed correctly. I offered, again, to pull up the documents right then on my phone. She didn't want to see them. The board doesn't need to review individual surveys for every situation, she said. Our guidelines are based on the original subdivision plat, and based on visual inspection, your fence appears to be encroaching by at least 2 feet into the buffer zone. Visual inspection, not a measurement, not a tape measure laid against a stake. A visual inspection, conducted, as far as I could tell, by someone standing on the sidewalk and eyeballing a 6-foot fence from 30 yards away. I asked her, still keeping my tone even, what specifically she was basing the 2-foot estimate on. She said she'd walked the property line the week before. I asked if she'd walked it with the actual surveyed boundary markers or with the general sense of where she believed the line to be. She bristled at that question, which told me a lot. I've been doing this for years, Marcus, she said. I don't need a survey to tell me what I can see with my own eyes. This is where I want to slow down for a second, because I think this moment captures something important about how these situations spiral. Denise wasn't acting maliciously in her own mind. She genuinely believed her years of experience and her visual judgment were more reliable than an actual legal document. That's not a small thing. That's the entire engine that drives a lot of HOA overreach. It's not usually pure cruelty. It's confidence that's wildly disproportionate to the actual expertise behind it. I tried a different approach. I asked her to point me to the specific HOA bylaw that gave the board the authority to determine property boundaries independently of a registered survey. She flipped through her clipboard, found Section 4, subsection C, and read it aloud. It said, verbatim, that structures must maintain appropriate setbacks as determined by official property documentation. Not by visual inspection, not by board discretion, by official property documentation. I pointed that phrase out to her directly. I said, Denise, this section says official documentation determines the setback. I have official documentation. I'd like to show it to you. She paused for a second, and for one brief moment, I thought maybe this was going to resolve itself right there in my driveway. But then she recovered and said something that, looking back, set the entire tone for the next month. I'll have the board review your documentation when you submit a formal appeal. Until then, the fence is in violation, and you'll be receiving a written notice. I asked her why an appeal was necessary for something I could prove right there, in under 30 seconds, on my phone. She said the process exists for a reason, and that she wasn't going to make exceptions by reviewing documents informally in someone's driveway. Which might have sounded reasonable, except that the entire interaction had started with her informally accusing me, in my driveway, based on nothing more than a visual estimate. The double standard wasn't subtle. She got to accuse informally. I had to defend formally. I let her finish, thanked her for coming by, and told her I'd be happy to participate in whatever formal process existed, but that I wanted it on record that I'd offered documentation at the very first opportunity, and that offer had been declined. She wrote something down on her clipboard, said something about the notice arriving within 5 business days, and turned to head back toward her car. Before she got far, I asked one more question, mostly out of curiosity. Denise, if I submit the appeal and the survey shows the fence is correctly placed, what happens then? She turned back around. Then the matter is closed, and we move on. And if it shows I'm wrong, what's the remedy? You'd need to relocate the fence to the correct boundary within 30 days, at your own expense, or face escalating fines. I nodded. That seems fair, as long as it goes by the survey. It will go by whatever the board determines is appropriate, she said, and there was a finality in how she said it that struck me as off. Not aggressive, but suggesting the board's determination and the survey's findings were 2 separate things that might not agree. I filed that detail away without fully understanding yet how much it would matter. She got in her car and drove to the next house on her route. I stood in my driveway for a minute, hose still in hand, running through the conversation in my head. Something about her tone bothered me, but I couldn't quite name it. It wasn't hostility, exactly. It was something closer to certainty, the kind that doesn't leave room for being corrected. I want to be honest with you about something. At that point, I wasn't worried. I dealt with people who were confident and wrong more times than I can count in my career, and the solution is almost always the same. Stay calm, document everything, and let the paper trail do the talking eventually. I genuinely believed that once the formal notice arrived, I'd submit my survey, the permit, and the contractor's documentation, and this would resolve itself within a couple of weeks. I went back to washing my truck. I didn't think much more about it that day. What I didn't know yet, and what I want you to keep in mind as this story continues, is that Denise Calloway had no real intention of letting documentation settle this quietly. Somewhere between that driveway conversation and the notice that arrived 5 days later, something shifted. This stopped being about a fence and started being about Denise needing to be right, publicly and decisively, regardless of what the evidence actually showed. That shift is what turned an ordinary HOA disagreement into something that would eventually involve a chainsaw crew, a sheriff's deputy, and a board meeting that people in that neighborhood still talk about. Before we go further, I want to ask you something. If an HOA president showed up at your house, accused you of a violation based on nothing more than a visual guess, and refused to even look at the documentation proving otherwise, what would you have done in that driveway? Would you have pushed harder right then, or would you have done what I did and waited for the formal process to play out? Drop your answer in the comments, because I think you're going to want to compare it to what actually happened next. The written notice arrived exactly 5 business days later, just as Denise had promised. It came in a plain white envelope, taped to my front door rather than mailed, which I noted because it meant someone, presumably Denise herself, had walked up to my house specifically to deliver it by hand. The letter was on official Brookhaven Estates HOA letterhead, and it cited the same Section 4, subsection C from our driveway conversation. It stated that my fence had been found, upon inspection by the HOA board, to be encroaching approximately 2 feet into the designated buffer zone, and that I had 14 days to either submit a formal appeal with supporting documentation or begin the process of relocating the fence. I want to point out something about that wording, because it matters. The letter said upon inspection by the board, not upon review of a licensed survey. That phrasing told me everything about how this decision had actually been reached. Nobody had pulled the plat. Nobody had measured anything with proper equipment. Someone had looked at a fence from a distance and decided, with total confidence, that they knew where the property line was. I did exactly what the letter asked. I drafted a formal appeal, attached a copy of my property survey, a copy of the county-issued fence permit, and the original invoice from my licensed contractor, which included a notation about boundary verification prior to installation. I submitted all of it through the HOA's official appeal portal, along with a short, professionally worded letter explaining that the documentation should resolve the matter definitively. I made sure to keep copies of everything, time-stamped, because that's simply how I operate. Old habits. For about 10 days, I heard nothing. Then I got a phone call, not a letter this time, from Denise directly. "I've reviewed your appeal," she said, without much of a greeting. Unfortunately, the board isn't convinced that a private survey overrides our own assessment of the buffer zone. I asked her to clarify what she meant by our own assessment, since the bylaws specifically referenced official documentation as the standard, and a licensed land survey is, by definition, official documentation. There isn't a more official source for boundary information than a survey conducted by a licensed surveyor and filed with the county. "The survey you submitted is for your property," she said. "It doesn't account for the HOA's buffer zone requirements, which are separate from the property line itself." This is where things started to genuinely concern me, because that statement was either a fundamental misunderstanding of how property law works, or a deliberate attempt to create confusion where none should exist. A buffer zone requirement, if one exists in an HOA's governing documents, still has to be measured from somewhere. It has to start at an actual, surveyed boundary line. You cannot have a setback requirement that floats independently of where your property legally ends. I explained this to her as clearly and patiently as I could. She didn't engage with the substance of it. Instead, she shifted the conversation entirely. "Regardless, the board has voted to uphold the violation. You have until the end of this week to begin relocating the fence, or the HOA will proceed with removal at the homeowner's expense, plus a daily fine of $50 until compliance is achieved." I felt my stomach tighten at that, not from fear, but from the particular kind of frustration that comes from watching someone escalate a situation that didn't need to escalate at all. "Denise, removal isn't something the HOA has the authority to do unilaterally on private property. That's not a minor procedural issue. That's a significant legal boundary. The governing documents give the board enforcement authority for violations, she said. I'd recommend you review Section 9 before you start telling me what we can and can't do. I did review Section 9 immediately after that call ended. It did grant the board authority to issue fines and, after an extended period of noncompliance and proper notice, to pursue removal through a legal process, which typically requires a court order in most states, including ours, when it comes to physical structures on someone's private property. It did not grant the board unilateral authority to send a crew onto someone's land and tear down a fence based on a disputed boundary claim that hadn't been resolved through any actual verification process. I called the county recorder's office that same afternoon, partly for my own peace of mind and partly because, frankly, I wanted a clean paper trail in case this kept moving in the direction it appeared to be moving. I confirmed that my survey was on file, that it matched the version I'd submitted in my appeal, and that no boundary disputes or amendments had been filed against my property since I purchased it. Everything matched. There was no ambiguity in the actual legal record. The only ambiguity existed in Denise's interpretation of where my property ended. Over the following week, the pressure kept building. I received 2 more letters, each one slightly more forceful in tone, each one referencing the daily fine, which by that point had been ticking upward for several days. I responded to each one in writing, calmly, reiterating the same documentation, reiterating my willingness to have an independent surveyor re-verify the boundary if the board genuinely doubted the accuracy of my existing survey. I even offered, in writing, to split the cost of an independent verification 50-50, just to put the question to rest definitively and avoid any further conflict. That offer was never acknowledged. Not once. I want you to remember that detail, because later, when this dispute reached the board meeting, it became one of the more telling pieces of the entire story. I had offered, multiple times, in writing, to resolve the boundary question through neutral, independent verification. Every single offer was ignored. Then came the call that genuinely worried me, about 2 weeks after the first letter. It wasn't from Denise. It was from a man identifying himself as a contractor the HOA had retained, asking to schedule access to my backyard for what he called fence remediation, scheduled for the following Tuesday. I asked him directly whether he had a court order or any legal authorization beyond the HOA's internal vote. He said he didn't know the specifics, only that the HOA had hired him and his crew, and that Denise had told him the homeowner, meaning me, would not be present and that he should proceed as scheduled. I asked him to repeat that last part. He confirmed it. Denise had told him I would not be present and that he should proceed anyway. That was the moment I understood this had stopped being a misunderstanding. Someone had specifically planned around my absence. I asked the contractor how Denise would have known I wouldn't be home that Tuesday. He said he didn't know, only that she'd been specific about the date and confident it would go smoothly. As it happened, I'd mentioned to one neighbor, in passing, that I might need to travel for a family matter. I never confirmed dates to anyone outside my immediate family. The fact that Denise apparently knew enough to schedule around my absence told me this had moved beyond a boundary dispute and into something that felt deliberately engineered to avoid any resistance. I called the HOA's general line and asked to speak with Denise directly. She wasn't available, so I left a message stating plainly that I had not agreed to any removal, that the boundary dispute remained unresolved, and that I expected no action on my property in my absence. I followed that call with a written email, timestamped, reiterating the same points, copying every board member whose contact information I could find on the HOA's website. I never received a response to that email either. I want to ask you directly, does this sound like an HOA enforcing a legitimate rule to you? Or does it sound like someone using a position of authority simply because they could? An HOA president scheduling work specifically around a homeowner's absence, ignoring repeated written offers for independent verification, and pushing forward despite a clear paper trail showing the fence was likely correct all along. Where's the line, in your opinion, between strict enforcement and an outright abuse of power? Let me know what you think, because we're about to find out exactly how far Denise was willing to take this. As it turned out, the family emergency that took me out of state for those few days involved my father, who'd had a cardiac event that, thankfully, ended up being manageable once doctors got him stabilized. I want to mention that not for sympathy, but because it's the actual reason I wasn't home that Tuesday. And it's worth understanding that the entire fence removal was scheduled and carried out while I was sitting in a hospital waiting room, dealing with something far more important than property lines. My neighbor, a retired schoolteacher named Carol who'd lived 2 houses down for almost 20 years, was the one who called and texted me the photos. She told me the crew arrived around 9 in the morning, that Denise showed up shortly after to supervise, and that the entire fence was disassembled by early afternoon. Carol said she tried to ask Denise what was happening, and Denise told her, rather matter-of-factly, that the HOA was correcting a long-standing boundary violation and that the homeowner, meaning me, had been properly notified and given every opportunity to resolve it. I called Carol back once I'd had a chance to absorb what had happened. She was apologetic, almost as if she felt responsible for not stopping it, which of course she had no obligation or ability to do. I told her not to worry about it, that this wasn't her fight, and that I appreciated her documenting everything as thoroughly as she had. She'd taken photos from multiple angles, including a few that clearly showed the crew working without anyone present from my household, and a few that captured Denise standing near the pile of dismantled fencing with what Carol described as a satisfied expression. For the next day or so, things actually went quiet. I focused on my father, who was recovering well, and I made a deliberate choice not to engage with the HOA by phone or in any heated way while I was still away from home. I sent one short, calm email confirming that I was aware the fence had been removed in my absence, that I considered this a serious matter, and that I would be addressing it formally once I returned. I didn't accuse anyone of anything in that email. I simply stated facts and reserved my position. There's a particular kind of calm that settles over a situation like this once the worst has already happened. The fence was gone. There was nothing more that could be physically done to it. In a strange way, that gave me room to breathe, because the most aggressive action Denise could take had already been taken. Whatever came next would be about resolution, not escalation, or at least that's what I told myself at the time. I flew home 4 days later, once my father was stable and discharged with a clear treatment plan. I drove straight from the airport to my house, dropped my bag inside the front door, and walked directly to the backyard before I even unpacked. The fence really was gone. Not damaged, not partially removed. Gone, exactly as the photos had shown, with the disassembled boards stacked neatly near the side gate, presumably left there for me to deal with as I saw fit. The yard looked strange without it, open in a way that felt almost exposed, and Tucker wandered the perimeter of where the fence used to stand like he was looking for it too. I stood there for a few minutes, taking it in, and I want to be honest with you about what I was thinking in that moment. I wasn't thinking about anger. I was thinking about the survey, sitting in a folder in my home office, and about a particular detail in it that I hadn't mentioned to Denise during any of our conversations, because frankly, it hadn't seemed necessary yet. There was a survey marker, an actual steel pin, driven into the ground decades earlier by the original subdivision surveyor, sitting at the exact corner where my property met the buffer zone. I knew it was there because the survey documentation specifically referenced its coordinates. I'd never needed to physically locate it before, because the fence line had always matched the paperwork. Now, with the fence gone and the ground exposed, I had a feeling that marker was about to become very, very relevant. I spent that first evening back home doing 2 things: documenting the state of my property with my own photos and video, time-stamped and detailed, and calling a licensed surveyor to schedule an emergency re-verification of my boundary line. I wanted someone neutral, someone with no stake in this dispute, to come out and physically locate that steel marker and confirm, on the record, exactly where my property ended. The surveyor, a calm, methodical man named Philip who'd been doing this work for over 20 years, came out 2 days later. I walked him through the situation, showed him my existing survey documents, and asked him to verify the corner marker referenced in the original paperwork. It took him about 40 minutes with his equipment to locate it, brushing back grass and a thin layer of soil until the top of the steel pin became visible, exactly where the documentation said it would be. He took measurements from that marker out to where my fence had stood, cross-referencing against the original plat. When he finished, he turned to me and said, plainly, that the fence had been installed correctly, within an inch of where the property line and the required setback actually fell. There was no 2-foot encroachment. There wasn't even a 2-inch encroachment. The fence had been exactly where it was supposed to be the entire time. I asked him to put his findings in writing, which he did, on official letterhead, with his license number and the date of inspection. That document, along with my original survey, the county permit, and Carol's photographs of the teardown, became the foundation of what I submitted to the HOA board, along with a formal written complaint requesting a hearing. I want to be clear about something here, because I think it's important. I didn't go to that hearing looking for a fight. I went because I believed, and still believe, that the proper response to someone overstepping their authority isn't to overstep back. It's to use the actual process that exists, calmly and thoroughly, and let the facts settle the matter. That's not just professional habit talking. That's genuinely how I think these situations should be handled, even when, maybe especially when, you have every reason to be angry. The hearing was scheduled for the following Thursday evening, in the small community clubhouse that doubled as the HOA's meeting space. It's a modest room, fold-out chairs in rows, a folding table at the front for the board. I arrived about 15 minutes early, set up my folder of documents on the small table reserved for residents presenting complaints, and waited as other board members and a handful of residents filtered in. I recognized a few neighbors, including Carol, who gave me a small, supportive nod from her seat near the back. Denise arrived a few minutes after me, clipboard in hand as always, and didn't make much eye contact as she took her seat at the head table alongside 3 other board members. I noticed she'd brought a thicker folder than usual, which I assumed meant she'd prepared something substantial. I hoped that folder contained an actual survey or measurement record, something that would finally put the boundary question to rest with real evidence rather than personal impressions. What I hadn't expected, and what changed the tone of the entire evening almost immediately, was the presence of a uniformed sheriff's deputy near the back of the room. I later learned that another resident, unrelated to my situation, had filed a complaint earlier that week about a different HOA enforcement action involving a vehicle towed from a driveway, and the county had sent a deputy to observe the meeting given the pattern of recent disputes. It wasn't there specifically for my case, but as the evening unfolded, it became directly relevant to it. The meeting opened with routine business, budget items, a discussion about the community pool schedule, and an upcoming landscaping contract renewal, before moving to my complaint. Denise presented first, and I want to describe her presentation as accurately as I can, because the tone of it matters. She told the board, and the room, that she had personally identified a clear encroachment based on her experience overseeing the neighborhood for years. She said she had given the homeowner, me, multiple opportunities to resolve the matter, and that I had been uncooperative and combative during our interactions. She said the removal had been conducted in accordance with the board's enforcement authority under Section 9, and that any suggestion otherwise was a misunderstanding of the HOA's governing documents. I want to point out, calmly, just how far that characterization drifted from what had actually happened. I had never raised my voice during any interaction with Denise. I had offered documentation at every single turn, in person, by phone, and in writing. I had offered to split the cost of independent verification. None of that was mentioned in her presentation. Instead, the picture she painted was of a difficult homeowner who'd ignored legitimate process, rather than a board president who'd ignored every offer of resolution. The deputy, who'd been quietly observing from the back, asked if he could ask a clarifying question before the board moved forward. The board president presiding over the meeting, a soft-spoken man named Harold who mostly deferred to Denise on enforcement matters, allowed it. "I just want to understand the timeline here," the deputy said, addressing Denise directly but in a tone that was entirely professional, neither accusatory nor dismissive. "You said the homeowner was uncooperative. Did he ever provide documentation supporting his position?" Denise hesitated for the first time that evening. "He provided a private survey, but private surveys don't override the board's own assessment." "What was the board's assessment based on?" the deputy asked. "A visual inspection of the property line." "Conducted by whom?" "By me," Denise said. "Are you a licensed surveyor?" "No, but I've been doing this for years. I know this neighborhood better than anyone." "I understand that," the deputy said, his tone still entirely even. "But I'm asking specifically about the property line determination, since that's a legal boundary, not really a matter of neighborhood familiarity. Was there ever a licensed survey or any official measurement taken before the fence was removed?" The room went quiet in a way that I can only describe as the kind of silence that has weight to it. Denise didn't answer immediately. She glanced down at her clipboard, then back up, and said something about having extensive experience with the neighborhood's boundaries over the years, which wasn't really an answer to the question at all. I watched her hands shift slightly on the clipboard in front of her, just enough movement that I noticed it, the kind of small physical tell that, in my line of work, you learn to pick up on instinctively. It wasn't dramatic. It wasn't a breakdown. It was just the quiet, visible discomfort of someone realizing, in real time, in front of a room full of people, that the question they'd just been asked didn't have a good answer. Have you ever seen authorities get pulled into something this small, a fence, a property line, a homeowners association dispute, and wondered how it ever escalated that far in the first place? I'd love to know if you've witnessed something similar, where a minor neighborhood disagreement somehow ended up involving police or county officials. Tell me about it in the comments, because we're not even at the most important part yet. Harold, the board president, cleared his throat and suggested they move forward to hear my side, presumably hoping to put a little distance between the deputy's question and the silence that followed it. I stood, thanked the board for the opportunity to present, and began laying out my documentation in the order I'd prepared it. I started with the original survey, the one I'd received at closing, walking the board through the boundary coordinates and explaining, in plain terms, how the fence line had been determined before installation. I passed copies to each board member as I spoke, along with copies for Denise, who took hers without comment. Next, I presented the county-issued fence permit, which included a notation confirming the contractor's pre-installation boundary check. Then the contractor's original invoice, which referenced the same boundary verification. I want to emphasize that none of this was new information. I had submitted all of it in my original appeal, weeks earlier, before the fence was ever removed. The board had simply chosen not to engage with it at the time. Then I introduced Philip's report, the independent surveyor I'd hired after the fence came down. I read his findings aloud, exactly as written. The property corner marker had been physically located. Its position matched the original plat to within standard surveying tolerance, and the fence, based on his measurements from that marker, had been installed correctly, with no encroachment into the buffer zone whatsoever. I watched Denise's expression shift as I read that section aloud. It wasn't dramatic, no gasping, no outburst. It was quieter than that, a kind of stillness that comes over someone when they realize the version of events they've been telling themselves, and everyone else, is about to fall apart in front of an audience. She interrupted before I could move to my next document. That survey was hired by you. Of course it's going to support your position. I responded calmly, which felt important in that moment, because the temptation to match her tone was there, but matching it wouldn't have helped anything. Philip is a licensed, independent surveyor with no connection to me beyond this single job. His license number and credentials are on the report, and his findings are based on locating an existing, decades-old survey marker, not on any opinion of mine. If the board has reason to doubt his findings, the county recorder's office can confirm the original plat independently. I'd welcome that. Harold looked toward the deputy, almost instinctively, as though seeking some kind of neutral confirmation that this was, in fact, how these things worked. The deputy nodded slightly and said, "That's accurate. Licensed survey markers and recorded plats are public record. The county can verify boundary disputes like this fairly quickly if there's ever doubt." That single confirmation seemed to shift something in the room. One of the other board members, a quieter man I hadn't interacted with much before, asked to see the contractor's invoice again, studying the boundary verification notation closely. Another board member asked Denise directly whether the board had ever requested or reviewed an independent survey before authorizing the fence removal. "We didn't feel it was necessary," Denise said. "The encroachment was visually apparent." "Visually apparent by how much?" the board member asked. "Approximately 2 feet. And the independent survey presented tonight shows zero encroachment, correct?" Denise didn't answer that one directly. She said something about needing to review the documentation more thoroughly before drawing conclusions, which, again, was the same offer to review documentation that she'd declined multiple times before any of this had escalated to where it now stood. I introduced my final piece of evidence at that point. Carol's photographs from the day of the removal, time-stamped, showing the crew working, showing Denise present and directing the process, and showing, crucially, the absence of any survey equipment, measuring tape, or marker location work being done before the teardown began. If the board's case rested on a 2-foot encroachment determined through careful inspection, there should have been some visible evidence of measurement. There wasn't any. Just a visual estimate, made from a distance, treated with the same confidence as an actual legal finding. I closed by stating, plainly and without embellishment, that I had documentation proving correct placement before the fence was ever built, documentation I'd offered repeatedly before removal, an independent post-removal survey confirming the same boundary, and photographic evidence that no verification process had been followed before the HOA acted. I asked the board to consider not just whether the fence had been correctly placed, which the evidence made fairly clear, but whether the process used to authorize its removal had followed the HOA's own governing documents at all. Harold thanked me, and the room sat in a kind of charged quiet while the board members exchanged glances. Denise opened her mouth to respond, then seemed to reconsider, closing the folder in front of her instead. For the first time that evening, she didn't have an immediate counter ready. The deputy, who had remained mostly quiet aside from his earlier questions, spoke up once more, addressing the board generally rather than Denise specifically. I'm not here to weigh in on HOA governance. That's outside my role. But from a legal standpoint, removing a structure from private property without a court order, based on a disputed and apparently unverified boundary claim, is something that could expose the association and potentially individuals involved to liability. I'd strongly recommend the board resolve the underlying boundary question through the county record before taking any further enforcement action of this kind. That recommendation, delivered calmly and without any theatrics, landed with more weight in that room than anything I could have said myself. I noticed a couple of the board members writing notes as he spoke, and Harold in particular seemed to straighten in his chair, as though the abstract idea of liability had suddenly become a much more concrete concern than it had been 5 minutes earlier. Carol, sitting near the back, later told me she'd never seen a board meeting go that quiet that quickly. She said it felt less like a homeowner's dispute and more like watching a courtroom shift in real time, where the weight of the evidence simply became too significant to argue around. I don't know that I'd go quite that far, but I understood what she meant. There's a particular kind of silence that settles over a room when people who were previously confident suddenly realize they don't have firm ground to stand on anymore. Harold asked if there were any further questions for either party before the board moved to deliberate. Nobody had anything further to add, including Denise, who sat with her folder closed and her hands folded over it, no longer reaching for the clipboard that had been her constant prop throughout this entire process. The board deliberated for about 20 minutes, stepping into a small side room while residents waited. I sat with Carol, who squeezed my arm at one point and told me, quietly, that regardless of what happened next, she was glad someone had finally pushed back with actual evidence instead of just frustration. I told her I appreciated that, and that frustration alone rarely solves anything in situations like this. Documentation does. When the board returned, Harold read their decision aloud, and I want to relay it as plainly as it was delivered, because I think the plainness of it matters more than any dramatic flourish would. He didn't raise his voice. He didn't editorialize. He simply read from a printed page, the way these decisions are usually delivered, fact by fact. The board found that the fence had been correctly placed according to all available official documentation, including the original survey, the county permit, and the independent post-removal verification. They found that the removal had been authorized and carried out without following the HOA's own governing documents, specifically the requirement that boundary determinations rely on official documentation rather than visual assessment. As a result, the board voted to formally rescind the violation notice, waive any outstanding fines that had accrued during the dispute, and authorize full reimbursement to me for the cost of reconstructing the fence, since its removal had been carried out improperly. That part alone would have been a fair and reasonable resolution. But the board didn't stop there. Harold continued, stating that given the manner in which the situation had been handled, including the decision to schedule removal specifically during a homeowner's documented absence, and the failure to engage with repeated, written offers of independent verification before taking irreversible action, The board would be initiating a formal review of Denise's conduct as president, separate from this specific complaint. Denise asked, somewhat sharply, what that review would entail. Harold said it would follow the same process outlined in the HOA's bylaws for any officer accused of acting outside their authority, which could range from a formal reprimand to removal from the board, depending on what the review found. I want to be honest about something here. I didn't ask for that review. My complaint, as I'd framed it, was about the fence, the documentation, and the reimbursement. I never specifically requested any disciplinary action against Denise personally. The board reached that decision on its own, based on the pattern of behavior the evidence had revealed, particularly the detail about scheduling the removal around my absence, which several board members described, almost identically, as the most troubling part of the entire situation. Over the following weeks, that review proceeded according to the bylaws. I wasn't part of the internal process and didn't seek to be, but the outcome eventually became public knowledge within the neighborhood, the way these things tend to. Denise was formally removed from her position as HOA president, though she remained a homeowner in the community. The board cited, in their public summary, a pattern of enforcement actions taken without adequate documentation or verification, not just my situation, but at least 2 other incidents that came to light once residents realized there was finally a process willing to take these complaints seriously. I learned later that the vehicle towing incident the deputy had originally been sent to observe, the one unrelated to my case, had also involved a similarly thin justification, a car towed from a driveway based on a parking violation that, once reviewed, didn't actually apply to the vehicle in question. That homeowner had been out of town as well when it happened. I don't say any of this to pile on. I genuinely don't take satisfaction in someone losing a position they clearly cared about, even someone who made the decisions Denise made. What I do think is worth sitting with is this. None of this happened because Denise was uniquely cruel or villainous. It happened because she'd been given a measure of authority, found very little resistance to it for long enough, and eventually stopped checking whether her confidence matched reality. That's a pattern that shows up far beyond HOAs, in workplaces, in small organizations, anywhere someone holds a bit of procedural power over other people, and I think it's worth recognizing wherever it appears, not just in a story like this one. The fence was rebuilt within 3 weeks, paid for by the HOA as the board had ordered, installed in the exact same spot, verified once again against that same steel marker that had been sitting quietly in the ground the entire time, waiting for someone to actually look for it. Here's something I keep coming back to. Do you think Denise actually expected this outcome when she scheduled that fence removal? Or do you think she was so confident in her own authority that the possibility of being wrong never even crossed her mind? I'm genuinely curious how you'd answer that, because I think it says a lot about how these situations escalate in the first place. Let me know what you think in the comments. In the months since all of this happened, the neighborhood has settled back into the kind of quiet I originally moved there for. A new HOA president took over, a retired engineer named Linda who, from what I've seen, takes a notably more measured approach to enforcement. Notices, when they're sent at all, reference specific documentation rather than visual impressions. Nobody has had their property altered without their knowledge since, and from what I understand, the board now requires a licensed survey or county record before any enforcement action involving boundaries can even be brought to a vote. I see Denise occasionally, usually from a distance, walking her dog or pulling out of her driveway. We don't talk much anymore, though our last real conversation, a brief one in the grocery store parking lot a few weeks after the board meeting, was civil enough. She apologized, somewhat stiffly, for how things had unfolded, and admitted that she probably should have taken my offer to verify the boundary independently months before any of it escalated as far as it did. I told her I appreciated that, and that I hoped she'd take something useful from it going forward. I meant that. I don't think people grow from being humiliated. I think they grow from being shown, clearly and undeniably, where they went wrong. I want to be honest about what I took away from this experience, because I think it matters more than the specific outcome did. This wasn't really a story about winning against an HOA. It was a story about what documentation, patience, and a refusal to escalate emotionally can accomplish, even when someone with a little bit of power is doing everything they can to make you feel like you don't have any options. I never raised my voice once during this entire ordeal, not in the driveway, not on the phone, not at the board meeting. I didn't need to. The survey, the permit, the contractor's records, and eventually that quiet steel marker buried in the ground did all the talking that needed to be done. There's a lesson in that, I think, that goes well beyond fences and property lines. When you're right, and you can prove it, the most powerful thing you can do is simply wait for the proof to matter, rather than trying to force the outcome through frustration or confrontation. The fence still stands today, exactly where it always belonged, exactly where that marker said it should be the entire time. So that's the story of how a fence, a clipboard, and one overconfident HOA president turned into a board meeting that this neighborhood will probably be talking about for years. If there's one thing I hope you take from this, it's that authority, whether it's an HOA, a landlord, or anyone else with a small amount of power over your property, isn't the same thing as being correct. Authority can move fast. It can sound confident, but it still has to answer to documentation eventually, and when it doesn't, that's usually when things start to fall apart for the person abusing it. I want to thank you for sticking with this story all the way through. If you enjoyed it, it really does help the channel when you hit that like button, and if you haven't subscribed yet, consider sticking around, because stories like this one are exactly what this channel is built on. Calm people, clear documentation, and HOA boards that occasionally need a sheriff's deputy in the back of the room to ask the one question nobody else thought to ask. And speaking of what's coming next, I've got another story queued up that involves a homeowner, a disputed parking spot, and an HOA fine that somehow turned into a small claims court appearance nobody saw coming. I won't say more than that for now, but if you found this story satisfying, I think you're going to want to be here for that one too. Before you go, though, I want to hear from you directly. If you've ever dealt with an HOA, a difficult neighbor, or someone who used a small amount of authority to make your life harder than it needed to be, I want to hear about it. Drop your story in the comments below. I read through them, and honestly, some of the best stories this channel has ever told started as a comment from someone just like you. So tell me what happened, how it resolved, and whether documentation, patience, or just plain stubbornness ended up winning the day. Thanks again for watching, and I'll see you in the next one.